to Dan, he fixed that. I'm going to check it right now. The previous exam.
I want to give you all some notes on admissions and confessions. Did you all look at the document that I sent you?
Yep.
That particular case, young girl out of Worcester, was, I actually had followed that when it first came along, and the conference that I went to at Suffolk Law a few weeks back, her attorney Ed Ryan presented. It's quite compelling. So I want to talk about that as well, but in the context of what particular rights.
You said you sent an email yesterday?
I emailed it on Monday, I believe. Wait a minute, I'm getting the days mixed up. I actually may have emailed it over the weekend.
Yeah.
Yeah. And it's a Word document, but within the Word document,
that was really strange.
There's links to the video of. I always pronounce her name wrong, and I'm looking for her name to say it correctly. Trong is her last name. Her first name is NGA.
This is the main thing. Okay.
Whoever didn't get the email, please email me again, because it's particularly important. I think that the videos are really short, but you have to watch those videos. I mean, there are a couple of the videos of her. You don't have to watch the news videos. That's fine. But of her confession.
The last one of her with her interview after the fact was amazing. It was like night and day.
Absolutely.
This poor kid.
Absolutely.
16, a dysfunctional family, a baby, just died, etc.
Absolutely.
Is this, oh, sorry.
Go ahead, Jadida.
Is this the video he showed at the conference that you're talking about? The 16-year-old girl? Oh, okay.
Yes. Oh, you were there.
Yeah.
Jadida was at this conference too.
Yeah. This is just the transcripts.
Yeah. And there's
Tony, where's Tony?
Tony.
Anthony Gargano.
He's not here. No. All right. So let's begin. I have a few categories to talk about with you. So one is just a basic rule on admissions and confessions for juveniles, and it's one of the Commonwealth v. Juvenile cases that you had to read. The #1 case decided in '83. So in '83, and you can just take notes if you want for now, and we'll talk about it again in the context of Trong's case. So in '83, the SJC promulgated these safeguards regarding juveniles' Fifth Amendment rights. Okay, so
safeguarded what? I'm sorry.
Safeguards regarding juveniles' rights.
Okay.
So for juveniles under 14, according to the case, the following had to be proven in order for the juvenile's waiver to be accepted. That each Miranda warning was given. That a parent, and so I'm talking about the juvenile under 14 now, that a parent or interested adult, and we'll talk about what an interested adult is, but that a parent or interested adult was present while the rights were given. That the parent or the interested adult, you could just say IA, okay, understood the warnings, and that the interested adult had the opportunity to explain to the juvenile so that the juvenile understood, and then consequently the juvenile waives knowingly and intelligently. So again, the Commonwealth v. Juvenile case stood for this proposition: juveniles under 14, the warnings are given, the interested adult is there, the interested adult understands, the interested adult explains to the juvenile understands, and then waives. 14 and older, although it's preferable that the same safeguards be used, you can still get a valid waiver without adult presence and consultation. The Commonwealth, however, has the additional burden of proving that the particular juvenile has a high degree of intelligence, experience, knowledge, sophistication. So again, 14 and older, preferable the parents are there, but it doesn't always happen. If it doesn't, then the Commonwealth has to show the juvenile has sophistication, intelligence, experience, etc. Now, you also had to read, let me see. I asked you to reread Galt, so just think about this. It all stems from Galt, right? The Fifth Amendment privilege against self-incrimination comes from the Galt case. What about Miranda warnings for juveniles? Again, failure to give Miranda is going to render the juvenile's confession inadmissible. When are Miranda warnings necessary? And we'll talk about that again in the nature of Trang's case. They're only necessary for custodial interrogations. One case that I didn't give you is Commonwealth v. Bryant. Bryant decided in '84. You don't need the site. What is custodial interrogation under Bryant? It's questioning initiated by cops, law enforcement officers, after a person has been taken away into custody, but this is important, or otherwise deprived of his or her freedom of action in any significant way. So, you normally think custodial interrogation, cops taking someone, but it also means that the person is deprived of their freedom of action in a significant way. And so the court looks to, it's almost a totality of circumstances approach. The factors, the circumstances surrounded the questioning in order to determine whether the individual being questioned might have believed that he or she was in custody. So there's a test that comes out of Commonwealth v. Phillips, a 1992 case. And it's just like that reasonable person test that you've talked about since your first semester of law school. It's how a reasonable person in the juvenile's position would have understood his situation. A reasonable person would have understood the situation. So the court takes into account these factors in terms of custody. The place of the interrogation, whether the investigation has begun to focus on the suspect, the nature of the interrogation, whether the interview was aggressive or informal or influenced, and whether at the time the juvenile makes the incriminating statement, whether the juvenile was free to end the interview, or by asking the interrogator, free to end, in other words, can I go now? Remember, Trunk said that at one point. The burden of proof, if this comes up at a motion hearing, the Commonwealth has to prove knowing and intelligent waiver beyond a reasonable doubt. And again, as I mentioned before, it's also the analysis the court goes through is a totality of the circumstances analysis. Back to the juvenile case. Again, that first case set the standard for the interested adult. That the interested adult had to be present, the interested adult had to understand again, had to give the juvenile, had to explain to the juvenile had to understand. So what's an interested adult? One case, Commonwealth v. Guyton, Guyton, decided in '89, says that a minor can't satisfy interested adult. In that case, it was the sister that was there that explained to the juvenile, and so that didn't satisfy the standard. Another Commonwealth v. Juvenile case, and again, you don't need the site, it was also a case decided in '89. A DYS employee, so the juvenile had been committed to DYS, and the DYS employee was trying to fit the interested adult standard, and the court said, no, that doesn't work either. Now, one of the cases that I gave you was Commonwealth v. McNeil, and in that case was the grandfather, and the court held that the grandfather did meet the interested adult standard. There was another one with the grandmother, Commonwealth v. Hogan, and defendant's mother happened to be out of town, father was in jail, so grandmother was there. And the court held that grandmother satisfies the standard. Now, here's some rules for, deciding the interested adult, not only in terms of who the interested adult is, but what the standard is. The facts are viewed objectively, supposedly, from the position of the officials who are conducting the interview. So if it's reasonably apparent to the cops questioning the juveniles that the adult lacked the capacity to appreciate the juvenile situation and to give advice, or was actually antagonistic to the juvenile, then it could be possible that even though there was an adult there, it could be mom or dad, that it's possible that that adult might not fit the interested adult standard. Now, getting back to the over 14, and that's what people get, it can become unclear. We talk about a meaningful consultation between the juvenile and the parent or interested adult, the opportunity if you're over 14. So as I said before, in certain instances, if you're over 14, you don't need to actually have the adult present, but you have to have the opportunity to confer with an adult. Did I give you the Commonwealth v. Phillip case? I don't think that I did. I just gave you McNeil. No, in your reading, no, I didn't.
92, reasonable person would have understood the situation.
In your reading, though, I didn't.
Oh,
so I want to tell you a little bit about that case. So the defendant in Phillip was 12 years old. Wow. Yeah, I thought he was that young. He was charged with manslaughter. During the interviews, he made oral admissions. He signed 2 statements admitting he set fire to a couch that resulted in a firefighter actually had died. Now, the juvenile's mother was present at the station. She and the juvenile were read their warnings. They were given time alone to consult. The mother encouraged the juvenile to tell the truth. The mother and the juvenile signed a waiver after they stated they understood the warnings. Okay. Now, the court rejected the notion that a parent who fails to tell a child not to talk to police, who advises the child tell the truth, is a disinterested parent. So it isn't, it doesn't mean just because the parent says, tell the truth, does that necessarily mean that that parent is doesn't fit the interested adult standard? Not necessarily so. Rejected the defense's suggestion that the Commonwealth should prove that the juvenile and the adult assisting him made full use of the opportunity provided to them actually to discuss the juvenile's rights and the consequences of the waiver, and reasoned it was appropriate to consider the juvenile's youth and inexperience with police procedures. So in the end, the SJC says, we're not going to adopt a fixed rule about the over 14 juvenile's opportunity to have a meaningful consultation with an interested adult. You have to look at the totality of the circumstances. It could be possible that a parent who was, overly aggressive in terms of tell the truth, and gets the juvenile to plea and sign a statement, it could be possible that that person might not be an interested adult. But the Commonwealth hasn't decided on an absolute per se standard relative to that. Again, if you presented with a real or factual scenario where parent or parental figure is doing things like that, you have to take into account everything: the juvenile's age, the juvenile's intelligence, experience, the brain science that we've talked about, you know, what the parent is saying. Is the parent under any kind of disability? You know, does this parent himself or herself have a mental illness? Or it comes to the police station not sober himself or herself for some reason.
I have a quick question. Would
yeah.
language be one of those things, a barrier, for example?
Absolutely. You know, again, totality of the circumstances, that could be something that you would, as defense counsel, you know, be arguing that even though the child had an interested adult with him, and maybe the child and the parent could converse, but the parent didn't understand, you know, what the police were saying, so how could the parent then explain to the child? Easier, obviously, with the under 14 child. Let's see, there's a few other cases, Alfonso, Leon. In Alfonso, how old was the juvenile? In Alfonso, the juvenile was 15, okay. Adjudicated delinquent, breaking and entering in the daytime, larceny over 250, possession of a firearm. Those were the charges, okay. So in Alfonso, the police interrogated the juvenile's adult that's right. There was an adult co-defendant with the juvenile. So they interrogated the adult co-defendant, then they questioned the juvenile. They confirmed his age, 15, read his Miranda rights, asked him if he wanted his mother present or wished to confer with it, remember, so that it's the meaningful opportunity, right? He responded he had been arrested twice before, knew his rights, and did not want his mother present. Okay. So then he waived his rights, he admitted he broke into the house, he took 5 or 6 guns, and then he moves to suppress the statements, of course. They always do that. So the SJC said that even though, although Alfonso's mother was home during the 2.5 hours in which police held him and his adult co-defendant, they made no attempt to contact his mother. After reading him his Miranda rights, police asked him whether he understood them. He asked whether he was aware of his rights because of the previous arrests. He stated he understood his rights. The SJC held that the ultimate question was whether the juvenile understood his rights and the potential consequences of waiver before he talked to the police. The motion judge had found that the repeated offers by the police to contact the mother gave the juvenile the opportunity to, you know, do you want to talk to your mom? No. Do you want to talk to your mom? No. The SJC disagreed, holding that the offers, get this, the offers did not amount to a genuine opportunity for consultation. For there to be a genuine opportunity, the interested adult must be informed and understand the juvenile's constitutional right. So this requirement connotes the presence of an adult, or at least contact between the adult and the police, so the police may inform the adult of those rights. The genuine opportunity is not theoretical. It requires an opportunity that is immediately available to the juvenile before waiver.
What year was that case?
Alfonso? Yeah, it was, I'll give you guys the site too. It's 2003, 438 Mass 372.
It's 433?
Yes. The court also, in Alfonso, said something interesting, that a juvenile in trouble may be embarrassed to ask for an adult's help. Again, the mother was in the same house. And the juvenile said, no, that's okay. I understand everything. The appeals court decided an interesting case, too, Commonwealth v. Leon in 2001. Jadida, Leon's mother did not speak English. Leon spoke and understood only broken English. I can't remember. I have my notes, and I don't know how old Leon was. Hold on a second. Yeah, he was 14. So I don't know whether he was under 14 or over 14. I have just that he's 14. What did he do? Arson. So he and his mother, so he and his mother end up going to the police station to talk to the police. Officer Lopez explains Leon's rights in English and Spanish. Okay. Both the juvenile and his mother sign Miranda forms. Leon signs an English version, his mother a Spanish version. The officers leave the room. They let Leon and his mother speak alone. They come back to question Leon with Lopez interpreting, and Leon denies involvement. Then another detective, Sabatalo, I can't pronounce his name, told them that somebody else had implicated, Leon and another kid, 13-year-old Kyle. So finally, after speaking with his mother and the Detective Lopez, Leon finally breaks down. He admits it. His answers get transcribed. Then Kyle and his mother, the other kid, come to the station after Leon. Lopez also acted as the interpreter, the cop. They signed Miranda waivers. And this is Carl again, the other kid. He denies involvement, he's crying, his mother was nervous. Carl's mother goes to the ladies' room. When she comes back, Carl is making a statement confessing involvement. His mother doesn't understand the interrogation. She gets distraught. At the suppression hearing, she testifies Carl was nervous and crying throughout the time. The judge concludes that the motions to suppress should be allowed because neither mother qualified as an interested adult. One's distraught, one doesn't understand the language.
Isn't that a conflict of interest, though, for the officer to be?
It very possibly could.
That's one of the reasons why on our job.
Richard has something.
One of the reasons why on our job we actually went to something called the language line.
Yep.
It's a service that a lot of police departments pay, and you basically call up this line. You say, and it's amazing the languages that they have. But I had to do one with Farsi, and someone, you call up, I need a Farsi interpreter, and 15 minutes later there's a guy on the phone, and you explain to him exactly what you're going to do. They have like copies of the Miranda waivers wherever they are. They'll read Miranda. They'll ask the questions that you ask them. It's pretty good.
Yeah.
So it's a good system.
So you're on a three-way phone?
No, basically what happens is you first talk to the interpreter. You'll tell them everything that you need done. You can give them a list of questions. They'll transcribe them, and then you give the phone to whoever needs the interpreter.
That makes more sense.
So these are some of the considerations in terms of, now, obviously, Trang, I'm still saying her name wrong. Somebody help me. Trong. I'm going to use the last name because the first name I can't even say. N-G-A. But we pronounce it. Na? Oh, Naga. Trong.
Just no.
Yeah, because when her attorney was pronouncing the name, and the first name was only one syllable.
He said, I don't remember, but I just remember the last name was Trong. So
Okay, so we'll go with Trong. So she was obviously she was over 14. She was 16. As somebody that has read the excerpt, and again, not everyone got the email. So if you didn't get the email about Trong, send me an email so I can send the document back to you. It might end up in your spam or something. Anybody want to just summarize? Lester?
Child was 16 with a child herself.
How old?
I want to say 17 months.
Yeah, very young.
13 months.
13 months.
16 months?
13.
Jeremiah said 13.
Oh, 13 months?
Yeah.
And she calls the police
Yeah.
to say that her baby has stopped breathing. And the police arrive, and she was correct. The baby is not breathing. The baby is not alive.
Not alive when the police come?
Correct.
Is he correct?
No.
Just
The baby was alive?
when the police come, because one of the people that came, and I don't know if it was a cop or not, did what?
They did CPR, and then the baby vomited into the cop's mouth.
Okay.
Go ahead, continue after that.
Well, I don't remember that. In any
So
event,
child is ultimately taken to the hospital, where child is then pronounced dead at the hospital, correct?
all right, it got past me.
That's okay, go ahead.
Trong is arrested, or she's taken to the police station, and she's superficially, allegedly, advised of her rights, which she waives. And at least according to this piece that you sent us, it would appear that there was excessive.
Who is she questioned by?
Two police officers, one was relatively silent.
For a while. He
And then
ends up later on.
the interrogator was quite aggressive. He had made up his mind to not to coerce, but to manipulate a confession from the suspect.
Was she, you said suspect, when she first was asked to come and speak, give her statement, etc., was she a suspect then? Joe says no.
I don't think so.
In their mind, she was, though.
What's that?
Said in the cop's mind, she was.
Well, that's an interesting point that you made, Joe.
It's going to be, they're going to look at it from the point of view of what her mind is, whether or not she feels she was in custody or whether or not she
Well,
feels she
that was going to be my next question, whether she was in custody. But in terms of her being a suspect, Jadida?
She wasn't told that she was a suspect. So like he said, they're going to look at the point of view, was she informed that she was a suspect? She was not.
Do you remember, Jadida, where you were at the conference? Judge Agnes spoke as well. The explanation of the type of interrogation that was going on.
No. If you bring it up, it'll
Coercive.
Well, it had to do with bringing someone in for questioning that isn't a suspect yet, and at some point during the questioning, you form the opinion, which could be subjective, that this person did it.
Okay, yeah. I don't remember what it's called,
Okay.
but I see where you're going.
Pardon me, Professor. I'm looking right at it. It says she called 911 and said Kyle isn't breathing.
Kyle wasn't breathing,
But he wasn't dead.
Wasn't dead.
he actually, when the officers came in response, did CPR on him. He actually, and that's something that comes up later on, and it's an important fact, Kyle actually vomited into the officer's mouth, and the officer actually then also went to the hospital because they didn't know what the infant had, what kind of disease or whatnot. Joe?
I was saying, I thought the interview, just on that portion, I thought it was more of a fact-finding interview, so it wasn't an interrogation.
Right.
It was an interview. It was a fact-finding, and then it develops to become...
Exactly, yeah.
Then it develops to become accusatory, in which case it's an interrogation.
Absolutely. Tim?
I thought it was more accusatory because they already believed she did it because her brother mysteriously died.
Okay, but again, she's not arrested. She's not given Miranda. Then the question is she in custody?
Yeah, no, but they were interrogating her as if she was
So
a
according to
suspect.
some of the rules that I gave you, how would you explain whether she's in custody or not? Because in order then to talk about whether her confession is false or not, you have to start with the point that she's in custody, right?
There's a
First, she
focus
wasn't
on-
arrested. They asked her to come in to speak to her. There was no adult. They didn't.
Okay, yeah, but you'll get into all of the mini arguments. Talk to me of whether she's in custody. What's the test?
Isn't that the one you just gave? The place of the interview and the
Yes.
focus of the investigation?
Tim, go ahead. Say it louder.
Place of the interview.
Okay,
Police
so
station.
she's in a closed room, 2 officers, most of the time it's 2, and I think at one point it was just the first, but 2 officers, closed door. We got to her age, Jadida, too.
If they focused on the individual, I'd say they were focused on her. It's not just they were asking questions. They went in there with the mindset that you already did this to your brother when you were 8.
Okay.
So I think they're focused on her. The nature of the investigation. They're focused on just basically, I think, getting a confession. They're not really interested in exploring other things. It says right in there. They're not looking for alternative theories or anything. They're just basically saying this baby was suffocated. You did it. Wasn't free to end the interview, obviously, because she asked if she could go.
She asked
They wouldn't
at
let her go.
one point during the interview whether she could go, and do you remember what the response was? Those of you that watched the video? John?
Well, I think in that situation, I think the article talked about maximization and minimization. I thought at that point they minimized, maybe they minimized it and said, if you want to, all you have to do is just agree that you suffocated.
Okay, that's the second guy. Let's talk. Yeah, let's talk about the first. We'll call them bad cop, good cop. Is that okay?
Yeah.
So so the first bad cop.
That's bad cop, just so you know.
What's that?
That's bad cop.
Joe's the bad cop. You're the good one.
I'm trying to minimize what he's saying right now.
So the first, as Tim said, is arriving at a conclusion that this child was, murdered by someone, even though that's not in the coroner's report and there's no indication that that had happened, right? And takes the questioning from that point of view. So tell me more about his questioning of this child. The first cop, Lester.
Well, he's tainted by, as I must confess, as I was when I read this, by the prior death of her brother, who was also
that's one piece of it.
Was also a child, and this officer.
What happened to her brother, and what age was she at the time?
She was 8.
She was 8.
8? Where was her mother? Tell us about her
In
home
bed.
situation. No, her mother
No,
was
but it wasn't in bed.
Her mother was gone, Lester.
No, she wasn't in the house.
She wasn't.
That's why she was child caring for her brother.
For her infant brother.
That's right.
I remember him saying she wasn't caring for the brother. She was actually sleeping. The mom left both of them in the house, and she just woke up and she's looking for her mom. She doesn't see her mom, and she goes to check on her brother,
Right.
and then notices that he's not breathing. So she wasn't caring for him.
Okay.
Says she left town.
Who knows? She wasn't there. So she still lives with that mom, who also has a young child, herself, who has a young child almost the same age. John?
Yeah. Even the idea of suffocation is not something that, so the officer is lying about the conclusion of a report that he doesn't know what the cause of death is.
Right.
But he says it's suffocation.
Yeah. So starts the questioning. He was smothered. Do you know who did it? He was smothered. He was someone must have done it. What was she doing? Could you hear her?
Barely.
Barely. So there's this
She was crying.
tiny 16, looking like probably 10 or 12, sitting across from the officers. So just the parameters of just watching this is so compelling. Seeing this, young child by herself being interrogated by these two cops. By the way, I got that it was an 8x10 room. Was it that small?
That's what it said.
Is that? Are they that small? Richard?
I hate to say this because I hate talking bad when I see police officers in these cases, but the fact of the matter is I think there's something that's in the article that I read that states it's like a classic example of what not to do. Mm-hmm. If you've taken a lot of interview courses, I've taken a lot of interview courses, and it's almost like everything that these two guys do is like the opposite of what you do. One of the big things is the room. When you take an interrogation course, you actually are taught how to design interrogation rooms to elicit statements. So, I mean, there are things that you do, like you don't put a table in I don't know, I didn't see the video, but you don't put a table in between someone. There's techniques where you touch someone, things like that. The other thing is, too, is one of the factors, and I don't think it's one of the ones that's enumerated, but the charges should be a factor in whether the statements are voluntary. If you're talking to a 16-year-old girl about shoplifting, it's much different than if you're talking to them about manslaughter
Very good
or murder.
point. That's right, that's right.
Another thing they teach you is never lie unless you have something so compelling. You know, there were cases where, you know, you tell them, oh, we got your fingerprints on the gun, but there's 3 witness statements, someone already is told on them and rolled a co-defendant or something. That's just not a good technique. And you just don't do a lot of the things they did unless you have stronger PC. One of the other things is, too, is they teach you in interrogation school, is the race of the person that you're interrogating has a lot to do with it, too. And Asians, in general, a lot are very non-confrontational. You know, something looking down when you're being spoken to is a sign of respect, rather than
not meeting there. Yeah.
So there's a lot of problems with this.
As you were talking, I found some of the quotes too. Pajot was that cop's name. That baby was smothered. Somebody smothered him. You have some bad luck watching kids. Your brother, how did he pass away? Then she says SDS, sudden death syndrome. Then he said there's no sudden death syndrome. How about big sister syndrome, he says to her. You're watching him when he died, in your care. You know, again, 8 years old, that baby mysteriously dies, and now Kyle, in your care, he mysteriously dies. Either you're a liar or you just got the worst luck in the world. How do you think a jury is going to see that? So, according to the attorney, this was pretty much psychological torture of this child without, of course, the presence of an interested adult. Joe?
Yeah, I was just going to say the same thing, just adding into what Rich said, is that I've conducted a lot of interviews, and suggestive line of questioning is okay.
Right.
What you really want to stay away from is drawing conclusions. You want them to tell you. So you can be suggestive in nature, whether it be a juvenile or adult, but you remember how she said she wasn't really talking? You want the response to come from her.
That's right.
If you plant the seed to say suggestive line, you want her to tell you. If she's not, then you need to back down on that and try and build a little bit more of a rapport. Because if you're just making statements, she's nodding her head, it's not going to work.
The same rationale that way back when we did the child sexual abuse assignment, the Lee case, how the cop and the social worker had interviewed the children at the time, which again was the improper form of leading questions. You said a lie, so here's Pajot says to her at one point, that medical examiner told me that the baby was smothered. Does that change your story, he says. We have scientific evidence. One day after his death, and believe me, we're still doing tests, I can tell you that boy was smothered. And then he goes, to death. So she's obviously, saying at the beginning, believe me, and please believe me, she's crying, I didn't do anything. And at some point, the other cop comes in. I forgot what his name was. So we have Pajot and Doherty, okay. And it's Doherty, as John pointed out before, that starts with you're just a kid. Come forward, gee, you're living in this awful situation where, it's really, the Department of Children and Families should be taking care of you and your family. We know the house is dysfunctional, it's a mess, your mother's unfit, this is a juvenile case, we'll take care of you. It's not fair, you should be able to be a kid, you're a kid trying to raise a kid. So that's the whole minimization theory that Doherty, the second cop. So when is it that she ends up lying, right? As a result of this questioning.
It tells you can go home if you admit to it.
So what does she admit to, and in what context?
She smothered a teddy bear.
I smothered Kyle. They make her say it,
right, yeah.
First of all. Say it again, or repeat it, we can't hear you. And then Doherty says, what did you smother him with? And then she says, the teddy bear. And right after she says that, guess what she says?
Can I leave now?
Is it okay if I leave now? What does that tell you?
clear.
doesn't
What
understand
you
what
said,
she's doing.
she was just opening the door to get out of there.
And before that, she did ask to leave, and then the one that was playing good cop goes, "Oh, let me ask the other guy." So they really,
So they didn't say no, but they sort of, yeah, well,
Yeah.
whatever, we'll get to that.
But
you know.
that's a clear indication that she has no idea what's going on.
Yeah.
Because I just confessed to murder, and can I go home now?
Can I go?
Yeah,
Is it
you can
okay if I
clearly tell,
leave
yeah.
now?
So she's focused on planning the funeral first, huh?
These are really tough because I hate to say it, but if you have a good interrogator, you could get anyone in this room to go, yeah, I did something. If it takes long enough and they take the right train and the right tact, it can happen. And you would think there's no way someone could make me say something that's not true. Absolutely true.
And by the way, she had not buried her son yet at the time of this questioning. She was then immediately arrested, taken into custody, and she asked, I have to go with you today. This has to be today. Joe says it has to be today. And she said, is it going to be more than a day? She was held for 2.5 years. 2.5 years. Until finally a Superior Court judge ruled that her statements were involuntary. So now, again, let's just try to reiterate all of the reasons why legally those statements, I smothered Kyle with the teddy bear, were involuntary.
One has to be the aggressive nature of the questioning.
Okay.
You got a 16-year-old kid, two police officers, grown men, are in your face saying yes, 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 yes. That's tough for any kid.
Okay. What else? Joe, I'll go down the road. Joe, go.
They were involuntary. She asked to leave, but right prior to these statements being made. So, I mean, at that point, the interview needs to stop. I mean, they could make some sort of, we're taught, not so much with juveniles, but in general in interviews, if somebody gets up and they want to leave, you stay seated in the interview and you try and talk to them from that point. But if somebody says they want to leave and they ask to leave, that's it. It's done. I mean, so they're going to find that portion of involuntary, anything after that anyways.
Okay, what else? Other people have the answer.
She didn't understand that she could invoke her rights to remain silent, to have an attorney. She didn't have that knowledge. She thought she was just in trouble. The way that she cooperated and just talked, you could tell that she didn't have the understanding that I can stay silent, I don't have to say anything. I need
And why didn't she understand from what you now know of juveniles?
Of her not knowing her Miranda rights?
Yes. You just said she didn't understand, blah, 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 blah.
Right.
Why didn't she understand?
Well, one, she wasn't explained, she wasn't told. Other than that, I mean, I would say, is it because of her age? And, well, she's
Didn't have a
pretty
high
young.
She's
didn't have a high
16.
level of
Yeah, she didn't
experience,
have- yeah.
intelligence.
Tim says she doesn't have a, so you're talking about the standard that I just read to you, Tim?
Yeah.
The high level of
She was
intelligence,
16, but she
experience,
didn't
etc.
exhibit like a clear understanding of it, obviously, because she was just asking to go home after she admitted it. So
What else can you say about her understanding? Joe?
It's debatable whether she's entitled to have an interested adult. Isn't that right? Even though she's over 14, but.
So what I heard from Tim is that in terms of the over 14 standard, that the Commonwealth wouldn't be able to prove that she has a high level of intelligence, experience, etc., that she would need an interested adult.
And I think
So,
that would be difficult given the nature of the interrogation. That if you're going to say that she understands her rights, well, why did the interrogation go the way it did?
Since you guys are still on the interested adult rationale, again, she's over 14, but what else has to happen to satisfy that?
They have to actually contact the adult, the parent or the interested adult, and they didn't do that.
There has to be an opportunity, right? The genuine opportunity to consult. And it could be, and suppose that even happened, We might then get into whether mom, in fact, understands. And again, is there a language issue, a culture issue? And, there could have even been more complications, with the interest in adult standard. But also getting back to her understanding, you also want to be raising the issue of juveniles' biological, neurological, etc. development. Just again, does this 16-year-old, even though the person's 16, almost at the stage where she wouldn't even qualify for juvenile court if it wasn't, murder, 16, going on 17. But if you raise the whole brain science, research, etc., then you could be making the argument that she doesn't understand any of these, her rights, her liabilities, etc. Sandra?
Especially for juveniles who've never had an issue or run into the law, never been arrested, never had any legal issues. A lot of people, surprisingly, which I'm going over with now with Professor Coppola, some people just really don't know their rights at all. And it's sad that they're in these kind of situations because they don't know that they can invoke it. And if you don't know that you can invoke it, then you can really find yourself in trouble.
Now, I said before she was held for 2.5 years. How procedurally do you think that happened? So she walked out of that interrogation room, and what happened to her procedurally? Knowing what you know now of Chapter 119 and the procedures and so forth. Jeremiah?
She would have been arrested, and then they would have made the motion to try her as an adult.
Well, slow down a little bit. So it wouldn't be a motion to try her as an adult. It would be, remember what the youthful offender...
Doesn't a district attorney have to decide?
So the district attorney would be filing an indictment, a youthful offender indictment against her, because again, she's in the category, the 14 to 17, threat or infliction of serious bodily harm. It's also, charges that would amount to felony, which is prison time, etc. So it all would fall within the definition of youthful offender. Again, the district attorney has the discretion to file a delinquency complaint or a youthful, I'm sorry, wait, whoa. She's charged with murder. Just forget everything I said. That would, everything I just said would apply if they decided to charge her with manslaughter. Okay, murder 1 and murder 2, the juvenile court doesn't even have jurisdiction. So there would be an indictment in the superior court, probable cause hearing in the superior court, trial in superior court for murders. But again, she's being held for 2.5 years. It's 2.5 years later that Attorney Ryan actually is able to get her out of detention because he won the motion. The case didn't go to trial. He won the motion to suppress.
The only thing I'm wondering, and again, I didn't have the email, but for that period of time, the only thing I can say is it's probably A, because her families obviously have not sufficient means, and if there was a bail, they probably couldn't raise it. Or, and the question I have is, was there a hearing as far as like a dangerousness hearing?
Good point.
Two children died in her care, supposedly.
Exactly. So one or two things. One is she's charged with murder, so there could be some high bail. Now remember that the bail statute 27658 applies to juveniles as well as adults. The rules of criminal procedure also apply to juveniles, delinquents as well. All right. So under the bail statute, if there was bail that, again, as Richard said, her family couldn't impose, she still would have had a right to appeal that to a Superior Court judge, just appeal the bail issue. She probably would have lost that issue. There could have been, under 58A, a dangerousness hearing. And the 58A was an amendment to the 58 bail statute some years back. And it's funny because I remember when it first got passed and there was a big hoop-de-doo whether it applied to juveniles or not. Ultimately, a case went to the SJC, Victor V., and the SJC held that the 58A hearings do apply to juveniles. So the district attorney can move and it's a different type of bail. It's called the dangerousness hearing, and it has its own burden of proof and everything, where district attorney would be arguing that this defendant pending trial can't be released to the public because the interest of public safety and certain crimes fall under that, domestic violence, etc. So she could have been held perhaps under one, those two particular statutes. Although, again, this is pending trial. And remember, we also looked at the Supreme Court case that Shaw v. Martin that held that pretrial detention of juveniles is constitutional. So again, 2.5 years this child was held until her, she won her motion and her case ultimately got dismissed. Yes.
Now, was it dismissed because of the video and that it was able to?
Absolutely.
So here's my question. So how come not? Well, I know that not all interrogations are recorded. Why is that?
Well, in the state of Massachusetts now, all interrogations are recorded.
Yeah,
that was something that came up. And the big thing on the interrogations is the police departments in general have to learn you can't get in trouble for doing more. So it's like when I deal with the juvenile on the street, and I'm going to talk to him on the street, if there's an issue where I think he might make a statement, I tell him right on the street, say, listen, don't tell me anything. I'm actually advising you to say nothing. We'll take care of it when we get back and talk to your mom, something like that. It's just, you can't get in trouble for that. If you do have a statement made, yeah, I committed the robbery on the street, the first thing that's going to happen is you're going to get a juvenile defense attorney that says, no right to consult with someone.
That's right.
Hurt yourself.
That's right. That's right. Commonwealth v. Diaz was the case. It wasn't that long ago. I think it was around the same time as the Youthful Offender Act was passed. So, if you find out that your juvenile client was not electronically recorded, bring a motion because they should be electronically recorded. Yeah.
Yeah. In New York, they don't record interrogations.
Yeah.
New Hampshire, they do juveniles, audio and video. Mm-hmm. Adults, audio only.
Now, what even after the motion went through, didn't it take 3 months for her to get out? I thought she said that in her video.
There's a big to-do is, finally, what her attorney did. He filed a civil rights lawsuit against the state. And he was joking about that there was and I don't know if that's true or not. Is there? That there's they counterclaimed against him for ineffective assistance of counsel because it took him so long to get her out. So I don't know. It's a good question as to why 2.5 years later the motion is finally successful. I'm not sure. I don't know. I really don't know. You could file pre-trial motions. I don't know when he filed it, Patricia. It's very interesting.
I was wondering
that particular question
from the start, because I remember him saying the minute she told him that something rang through his body, he was like, she's not lying, and he doesn't usually feel that with other clients. So I'm wondering, was he her attorney from the beginning?
Oh, I don't know. He must have been, because again, that his statement that the state was saying that he took so long to get her out. So I don't know. It's a very interesting question. Whether I am going to give a review on Thursday, and make sure you get this email because it's just a document, one sheet, and it's just terms. Legal terms. And it's pretty much, that sheet kind of contains all the issues you'll encounter in one way or another for the exam. So print it out yourself. I'll be going through that. And if the online students are listening and if they want to, they can come to sometimes some of the online students, if they have time, will sometimes come to the review. Make sure that Jeremiah was saying before class and about the past juvenile law exams that should be on file.
The latest ones are 2003, 4, 8, 10, and 12.
Okay, so
and
there's
then it
plenty
goes all
there.
the way back to the 90s.
Okay, and this is electronically. This is on MS Law.
Yeah, MS Law website.
Yeah.
Exam prep.
Yeah, and I think that the library desk has hard copies. I could be wrong. So,
I know when I've asked for hard copies before, they don't really like that.
Okay.
Depends on who's down there, but
Okay.
often they don't like you to take them and copy them.
Okay.
They just say go online.
okay, yeah, and that's the easiest thing to do anyway. So,
In case you're willing to tell us, I mean, in the interest of time, are the 1992, 3, 4, and 5 exams worth reading?
not really,
Just check.
not really, because, because, you know, before 96, we weren't talking about youthful offender. Those exams may have been talking about transfer hearings, but at the same time, the rationale is still the same for sentencing, you know. So if you have a youthful offender, the court is still going to consider after his or her trial the same sort of factors that the courts way back when decided whether to transfer a kid or not. You know? So yes and no, I'm sort of rethinking. I mean, you don't, obviously you might not have the time to look, to practice
It's a
every
huge
single
amount.
exam.
When you go online,
It's a lot.
You have
Yeah.
55 pages of prior exams on the website.
Yeah, yeah. So go for the, you know, the most recent and, you know, practice how you would answer them, you know, as part of your preparation. That's it.
Yeah. 20, and looks like 25 of those pages are from the 90s.
Yeah. So then if you look at 2012, 2000, I don't know why they don't have 2011.
Yeah, like I said, it went 3,
It's
4, 8,
kinda odd.
10, 12.
Okay. At the same time, I probably have more finals I did posted than anyone else. Anyways. All right, so review, and again, search and seizure is still, it is a huge issue, but we just don't have time. You have pretty much the case law, should you have to do research for an attorney on a school issue at the end of your packet, you know. And remember this, you know, again, it still comes down to the very simple premise that juveniles and adults are different. You know, for example, the U.S. Supreme Court had held way back when in New Jersey v. TLO that you just had it, you know, that school officials could have a different, there still had to be a standard. Juveniles still have constitutional rights, but just not the full panoply that adults would have. So whenever you're dealing with a school, any kind of school issue, you want to remember that. You want to remember that there are some rights, but they're not, probably not going to meet the stricter standards, because the juvenile's liberty isn't as at issue as a juvenile that's facing, you know, delinquency charges, for example, that could be committed to DYS. But again, there'll be nothing on the final with relation to that. Right, so we'll do our review on Thursday. I'll see you then. Thank you.
Thank you.